Chief Justice Gates and fellow judges, Attorney General Raja, distinguished guests, ladies and gentlemen. It gives me great pleasure to deliver the opening address for the 2016 Global Pound Conference Series. More than a century ago, in 1906, at the 29th Annual Convention of the American Bar Association, Professor Roscoe Pound delivered a speech entitled "The Causes of Popular Dissatisfaction with the Administration of Justice." In that speech, the then 36-year-old dean of the University of Nebraska College of Law spoke of the real and serious disaffection with courts and lack of respect for law, which he thought existed in the United States at that time. 70 years later, in 1976, a group of judges, government officials, and practicing lawyers gathered in St. Paul, Minnesota, to address the causes and the remedies for popular disaffection with the administration of justice. That marked the birth of the Pound Conference, which was named in honor of Roscoe Pound. At the inaugural Pound Conference, Professor Frank Sander of Harvard Law School proposed that alternative forms of dispute resolution could be used to reduce reliance on conventional litigation. And he proposed ways in which he could overcome the reluctance to have recourse to such options. That first conference had an immense impact on how we have since come to think about the way in which disputes should be resolved, and it has been widely credited for the emergence of modern dispute resolution systems, including in particular the rise of alternative dispute resolution. Today, some 4 decades later, one might contend, perhaps with some force, that the legal landscape has changed dramatically. Some might say that we no longer live in an era where people take a widespread, disenchanted, and disaffected view of the administration of justice in the courts. Others might acknowledge the rise and entrenchment of alternative dispute resolution processes such as arbitration and mediation, popularly known today by the acronym ADR. Taken together, one might conclude that a reasonable balance has been struck in many jurisdictions which feature strong judicial institutions coexisting alongside thriving ADR communities. Whether or not this view is well-founded, I suggest the foundational aim of the Pound Conference, which is to further the development of ideas to enhance access to justice by improving dispute resolution processes, remains wholly relevant today as it was at the time of the first Pound Conference, or even at the time Dean Pound gave his seminal address. We must continue to analyze the major shifts in the global landscape and to anticipate new movements, particularly those relevant to the resolution of disputes. This morning, I propose to touch on 3 such shifts and thereafter to share my thoughts on possible systemic responses to them in order that our legal systems might remain relevant in changing times. These responses might help us to better shape the future of dispute resolution and improve access to justice in the years to come. We are today witnessing unprecedented growth in transnational trade and economic partnerships. This is the effect of globalization, a term that describes the increased international integration in commodities, capital, and labor markets. In this context, the first major shift that we can readily identify is a movement towards increased economic openness and increased mobility of labor and capital. This is well illustrated by a series of initiatives in Asia and the Pacific. I begin with the establishment of the ASEAN Economic Community on the 31st of December 2015. This is a major regional economic integration effort that aims to unify Southeast Asia's diverse economies into a single market and production base so as to facilitate the seamless movement of goods, services, investment, and capital, as well as skilled labor within ASEAN. Further afield in Asia, many would have heard of China's plans to develop a new Silk Road, otherwise known as the One Belt, One Road initiative, which was unveiled just a few years ago. Through this development strategy and framework, China aims to create multiple economic corridors encompassing more than 60 countries throughout Asia, North Africa, and East Africa, and in the process linking the dynamic East Asian Economic Zone with the advanced European Economic Zone. The One Belt, One Road initiative consists of two main components: the land-based Silk Road economic belt and the ocean-going maritime Silk Road. It seeks to build 5 connectivities which comprise policy consultation, infrastructure connectivity, free trade, free circulation of local currencies, and people-to-people connectivity. China has pledged to invest more than $200 billion in Silk Road projects across the globe, including the development of roads, rails, oil and gas pipelines, ports, and other infrastructure. This will increase connectivity and cooperation amongst the community of nations, develop regional infrastructure, and improve trade and relations. Alongside the One Belt, One Road initiative is another brainchild of China, the Asian Infrastructure Investment Bank. The specifics of this financial framework are a topic for another day, but for now it suffices to say that both the Asian Infrastructure Investment Bank and the One Belt, One Road initiative seek to enhance economic integration amongst countries by improving connectivity and strengthening the supporting infrastructure of trade. And a final example of increased economic openness is the Trans-Pacific Partnership Agreement, or the TPP, which was signed very recently on 4th February 2016. The 12 signatories, including Singapore, together represent an estimated 40% of global GDP, 1/3 of world trade, and a combined population of about 800 million people. The TPP is a multilateral investment treaty that touches on matters concerning regional economic policy. It will come into force if all 12 members ratify it within 2 years, or if the United States, Japan, and 4 other TPP countries ratify it after the 2-year timeframe. If and when it comes into force, we will see the birth of what has been described as one of the most ambitious free trade agreements ever, and the largest regional trade arrangement to date. With the shift towards increased economic openness and increased mobility of labor and capital, we can expect cross-border trade to continue growing. Correspondingly, we should anticipate that this will be accompanied by an increase in transnational commercial disputes that span an ever-expanding range of subjects and involve parties from a growing number of jurisdictions. It is inevitable that legal systems will have to deal with the reality that cross-border business disputes are going to become commonplace. The second major shift is closely related to the first, namely a shift towards cross-cultural convergence in dispute resolution. Globalization has brought with it a sharp increase in the incidence of transnational commercial disputes. But national legal systems, which were primarily designed to deal with intra-jurisdictional domestic disputes, have struggled to deal efficiently with transnational ones. Indeed, the very existence of different legal systems significantly increases the transactional costs of doing cross-border business. Parties in cross-border businesses will inevitably have to expend resources in attempting to secure compliance with a web of national laws and regulations. And when disputes arise, they then have to invest further resources to navigate often unfamiliar legal systems. Often they will have to rely on unfamiliar foreign counsel, as well as to bear the additional risks that accompany the cross-border enforcement of judgments. On the one hand, these constitute barriers or obstacles to international trade. On the other hand, this is the backdrop against which there has been a drift towards cross-cultural convergence in the resolution of disputes. The rise of international commercial arbitration is perhaps the best illustration of such convergence. Arbitration rose to prominence by allowing parties to resolve their transnational commercial disputes in a neutral forum, away from national legal systems that might not be optimally designed for such purposes. It provided an option for minimizing the transactional costs of doing cross-border business. Arbitration also afforded much-needed flexibility to disputing parties who might often hail from diverse backgrounds and be accustomed to diverse laws and legal practices. One example of such flexibility is that relating to party representation. Unlike in traditional national court systems, where as a general rule only lawyers qualified in the relevant jurisdiction have the right of audience before the courts, in arbitration, disputants can usually continue to rely on their preferred legal advisors and counsel to represent them in proceedings. The growth of international commercial arbitration also provides an excellent example of the cross-fertilization of civil and common law concepts, providing a testbed for developing best practices in resolving transnational commercial disputes. The rules and guidelines developed by the International Bar Association serve as important illustrations of this point. For instance, the working party that prepared the IBA rules on the taking of evidence consisted of 16 arbitration practitioners drawn from a mix of civil and common law jurisdictions. The resulting set of rules reflected procedures initially developed in civil law systems, common law systems, and in international arbitration processes, and may be considered as presenting a hybrid or fused model for regulating the taking of evidence. Another example is the IBA guidelines on party representation in international arbitration, which sought to provide a uniform standard to regulate counsel conduct in the face of the diverse and potentially conflicting rules and norms in this area. The task force that drew up these guidelines consisted of practitioners from a good mix of civil and common law backgrounds. These rules and guidelines have proved to be tremendously useful, particularly as it is no longer uncommon to find a mix of civil law and common law practitioners contemporaneously playing different roles in a single arbitral matter. The cross-fertilization of ideas has also had a salutary effect in promoting cross-cultural convergence, and there have been recent calls for this to continue. The third major shift that I will touch on is the growing recognition that access to justice can take place outside the courtroom. Gone are the days when disputants believed that their quest for justice could only be pursued in courtrooms. Increasingly, disputants look beyond the traditional court-based approaches to resolve their differences. I have already alluded to arbitration's much-needed role in facilitating the resolution of transnational commercial disputes. But arbitration is not the only means for accessing justice outside the courtroom. There is growing recognition of the important role that mediation has come to play as a viable mode of dispute resolution. One of the key features of mediation is its flexibility, which enables the parties to explore a multitude of issues and concerns arising out of a transaction or a relationship, including considerations that might not strictly be legal in nature. The flat structure of mediation, which involves a neutral facilitator rather than an adjudicator, is often conducive to the parties settling their disputes privately and amicably. The process allows them to directly participate and interact with each other in the effort to find a mutually acceptable solution. And importantly, it allows them to determine the outcomes of their dispute instead of having a tribunal do so. Mediation also has the great benefit of being much less costly than most other modes of dispute resolution. The benefits of mediation have come to be appreciated across the board, from family or matrimonial disputes to business partnerships and commercial relationships. This is a trend that appears to be gaining momentum, and we should encourage this. Let me pause here to pull these threads together. I have highlighted three major shifts that should inform the manner in which we should approach the development of our dispute resolution mechanisms. First, a shift towards increased economic openness and mobility of labor and capital. Second, a shift towards increasing cross-cultural convergence in transnational commercial dispute resolution. And third, a shift towards the increased recognition that access to justice can take place outside the courtroom. Against that background, let me outline three possible responses to these shifts that could help us shape the future of dispute resolution, even as we look to enhance access to justice. The first, I suggest, is to equip legal systems with a diversified range of dispute resolution options. In this regard, we should focus on the provision of appropriate mechanisms to resolve the dispute at hand. I mentioned earlier that the acronym ADR is commonly understood as a reference to alternative dispute resolution. This carries a value judgment of the widely held notion that such mechanisms are merely alternatives to the mainstream and conventional method of court-based dispute resolution. However, retaining the terminology of alternative might mislead us for this reason, whether consciously or otherwise, into believing that the default or even the best approach is to be found in court. While the court-based approach to dispute resolution certainly has its strengths, it may not always be appropriate in every case. For instance, resorting to a multiplicity of litigation actions across different national courts might not be the most efficient or effective way to resolve a transnational commercial dispute. Indeed, other than the excessive cost and effort involved, such a piecemeal approach will often prove unsatisfactory given the unpredictable and sometimes conflicting outcomes that emerge from different courts in different jurisdictions. The long-running patent wars between leading international IT companies attest to this. Some of these long-drawn battles have since seen a ceasefire. For instance, Apple and Google announced in 2014 that they had agreed to settle all direct outstanding patent litigation between them. And in September 2015, Google and Microsoft arrived at an accord to discontinue all pending patent litigation between them. Another example may be found in the context of family justice. As already alluded to, mediation may be more suitable than court-based litigation in the resolution of family disputes where the preservation of continuing familial relationships is a priority. An ideal system of justice is one that delivers justice that is customized to each type of case, keeping in mind the subject matter, the parties, and the sought-for outcomes. This is a situation where one size does not fit all. In this regard, it would perhaps be timely to embrace a paradigm shift and understand ADR as a reference to appropriate dispute resolution instead. This invites us to move away from our traditional and rigid ideas of how disputes should be resolved towards a flexible and option-laden model where disputants are well placed to choose the ideal mode of dispute resolution from a suite of options. Let me emphasize that the call for appropriate dispute resolution should not be seen as suggesting a reduced role for the courts. Even with the development of other dispute resolution options, the courts retain a special place in society as the guardians of the rule of law and oftentimes the principal and authoritative resolver of legal disputes. As such, quite the opposite of taking a reduced role, courts should embrace the reality that different disputes that come before them call for different measures and hence seek to be equipped or even redesigned to resolve disputes as appropriately as possible. I touched briefly on three ways in which the courts could do so. First, some degree of specialization of the bench could be useful, given that different knowledge bases and skill sets may be required for resolving different types of disputes. For instance, commercial and technology matters could be entrusted to judges who are experts in these areas, while criminal and family justice disputes could be dealt with under different procedural rules. Many courts, including the English and Singapore courts, have recognized the need for such a calibrated approach to specialization and the docketing of cases. Second, recognizing that certain subjects may require the input of specialists in certain disciplines or areas of law, the courts might endeavor more frequently and readily to use experts, assessors, and amicus curiae to enhance the robustness and correctness of their decisions. And third, With the unique role entrusted to courts to interpret and, where appropriate, to develop the law, courts could endeavor to play an active role in developing a coherent body of jurisprudence in transnational commercial cases. This would help to provide guidance for commercial parties, enhance the predictability of outcomes, provide yardsticks for international standard setting, encourage transnational conversations on substantive principles of law, and possibly in time even provide a basis for the development of a lex mercatoria. While international commercial arbitration has played a part in initiating this process, there are limits to what it can accomplish in this context. This arises because arbitration is generally regarded as an ad hoc, consensual, convenient, and confidential method for resolving disputes. It is neither designed nor well placed to develop an authoritative and legitimate superstructure of legal norms to facilitate global commerce. In contrast, court proceedings are generally more transparent in the interest of open justice, and the appellate mechanisms available are invaluable for correcting errors, enhancing consistency, and creating reliable judicial precedents. I suggest that litigation, arbitration, mediation, and other dispute resolution methods should each play to their respective strengths and weaknesses as we move towards promoting appropriate dispute resolution. The second response I propose is that of increasing convergence through conversations and communications amongst the relevant stakeholders, so as to chart a coherent developmental pathway for the evolution of dispute resolution mechanisms. Learning from beyond one's borders is of tremendous value because the refinement and development of practices is a long, drawn-out process that involves repeated imagination, experimentation, verification, and refinement. In due course, greater convergence coupled with more conversations and communications might even enhance the recognition and promotion of the rule of law. Insofar as increased convergence, conversations, and communications are concerned, I believe that we are already moving in this direction. In 2013, in a speech I made in London, I suggested that the opening act in a three-act convergence effort could be the harmonization of the rules on the recognition and enforcement of judgments. Since then, the Hague Convention on Choice of Courts Agreements has entered into force just last year on the 1st of October, and it is currently operating in Mexico and all the members of the European Union, save for Denmark. The convention promises to do for court judgments what the New York Convention has so successfully done for arbitral awards, and it promises to be a real game changer insofar as the international enforceability of court judgments is concerned. This, in my view, is a very important step towards convergence. I had also suggested then that Act 2 of the convergence effort might be the development of deeper connections amongst courts and the exploration of further avenues for knowledge sharing and substantive collaboration. There have been encouraging developments on this front too in recent years. For instance, courts from Australia, the Dubai International Financial Center, England and Wales, Korea, New York, and Singapore, to name a few, have separately entered into memoranda of understanding or guidance to clarify, amongst other things, the procedures for mutual reference of questions of law to one another or for the enforcement of each other's judgments. We have also seen an increase in court-to-court conversations on matters ranging from intellectual property and cross-border insolvency to international family law. Singapore has been particularly active in such conversations. For example, we are currently working with judges from several key commercial jurisdictions on issues relating to cross-border insolvency and are looking to establish an international cross-court network connecting the courts of these jurisdictions in due course. We have also seen an increasing cross-fertilization of civil law and common law ideas in specific areas of law. Discovery is one such area. In recent years, possibly in part inspired by the civil law practice in which parties litigate without the equivalent of common law discovery, and perhaps partly because of its prohibitive and often disproportionate cost. Major common law jurisdictions such as the US and the UK have moved towards circumscribing the discovery process. In Australia, the right to general discovery has been removed in the federal court, as well as in the courts of New South Wales and Western Australia. On the other hand, the civil law world has begun adopting some common law ideas on the production of documentary evidence in selected areas. For instance, at the European Union, a recent directive on antitrust private enforcement proceedings introduces the concept of categories of evidence in addition to specific items of evidence. And commentators have observed this to be a complete novelty for some civil law jurisdictions, as it provides a much broader range of document production. The cross-fertilization of ideas thus seems to have led to increasing convergence in the approaches towards document production. Selected examples from Singapore's experience will further illustrate the cross-fertilization of ideas. In the context of family justice, the Committee for Family Justice studied, amongst other jurisdictions, the German family justice system and observed the roles played there by judges and child representatives. This inspired the judge-led approach for resolving family disputes and the subsequent introduction of child representatives in our family justice system. In the context of medical litigation, we're now considering a possible shift from the present purely adversarial common law model to a process in which the judge, with the assistance of an expert assessor, proactively directs the proceedings using a model that might more closely be seen to be associated with the civil law tradition. As yet another example, proceedings in the Singapore International Commercial Court are governed by a unique set of rules that incorporate elements of international best practices, which makes its processes conducive to users coming from both the common and the civil law worlds. For instance, while generally retaining the common law adversarial framework, the SICC disapplies the common law discovery regime in favor of a regime similar to that commonly adopted in some civil law jurisdictions and in international commercial arbitration. In the SICC, parties also have increased autonomy and flexibility working with the judge to design procedures appropriate for the case. For instance, parties may agree that evidential rules other than those contained in Singapore's Evidence Act shall apply, and may also agree to exclude, limit, or vary the right and scope of appeal. Aside from this, there have also been many courses and conferences organized specifically to facilitate the exchange of ideas and best practices across jurisdictions. We have seen increasing interest and awareness from varied stakeholders in the convergence of cross-border substantive business laws, in improved legal infrastructure and regulatory standards. Most recently, in January this year, an international conference on doing business across Asia, Legal Convergence in an Asian Century, was hosted in Singapore, and it drew more than 500 delegates, including policymakers, members of judiciaries, legal practitioners, business leaders, and academics. It was fitting that the Asian Business Law Institute, or ABLI, was launched at that conference. ABLI has amongst its core tasks that of evaluating and stimulating the development of Asian business law, legal practice, and policy. In particular, ABLI aims to make proposals to facilitate the convergence of commercial law in the region and will provide an important platform for key stakeholders to work together on this important initiative. Greater convergence in substantive rules and principles of law will enhance the consistency of outcomes across jurisdictions and hence reduce the legal costs for parties who inevitably will operate to an increasing degree across multiple jurisdictions. It can also reduce the incentive for parties to forum shop in a bid to obtain favorable results. Frequent conversations and communications amongst the relevant stakeholders will facilitate the synthesis of ideas and the distilling of international best practices. There is wind in the sails of the convergence movement, but we must ensure that the conversation neither stagnates nor stumbles along on a piecemeal basis. We cannot leave the evolution of our dispute resolution mechanisms to happenstance. Against the backdrop of the changing landscape of global commerce, we need to press on towards greater legal convergence of our frameworks, as this will yield efficiency, transparency, flexibility, and consistency in dispute resolution. And this is precisely what ABLE seeks to ensure. The third and final response that I wish to touch on is that we should grasp the opportunity that is presented by the reality that today we have access to a global talent pool in a flattened world. With increased economic openness and mobility of labor and capital, it is unsurprising that an increasing number of legal practitioners, academics, and even judges work outside their home jurisdictions. In recent years, we've seen the internationalization of law firms as illustrated by the increasing number of foreign law firms opening foreign branches or entering into partnerships with other law firms. We've also seen an increase in the number of international arbitration tribunals, universities with an increasingly international outlook, and even international courts. We should embrace the increasing internationalization of legal services. However, the global talent pool must be carefully managed and regulated so as to ensure that issues do not arise from a clash of cultures, inconsistent practices, or unethical or different approaches to ethics. To give an example, in recent years, there's been a move towards the liberalization of our legal industry, including the extension of rights of practice in Singapore to various types of foreign law practices, accompanied by the recognition of law degrees in selected foreign universities. To put this in context, as of June 2013, foreign lawyers formed approximately 20% of Singapore's total population of lawyers. With the increase in the number of foreign lawyers practicing in Singapore, we have seen it fit to establish a common disciplinary and regulatory framework for both local and foreign lawyers who practice in Singapore. To this end, we have promulgated rules relating to professional practice, etiquette, conduct, and discipline that apply to all legal practitioners. And in the process, by tapping and managing the global talent pool, we've been able to further strengthen our position as a legal hub in the region. It has to be said, however, that Singapore does not only import legal talent. The reality is that we also export it. Our universities have produced many excellent young lawyers, a number of whom practice in international law firms based both in Singapore and worldwide. And indeed, one eminent Singapore lawyer currently serves as the Chief Justice of the Dubai International Financial Center Courts. Perhaps the most vivid illustration of tapping on the global talent pool is found in the establishment of the Singapore International Commercial Court. Alongside commercial judges from Singapore, the SICC's panel presently features 12 eminent international judges hailing from various jurisdictions, each possessing deep commercial expertise and representing a good mix of both the civil and common law traditions. The SICC also offers liberal rights of audience for foreign lawyers who are registered with the SICC, the criteria for registration being much less stringent than for the admission of Queen's Counsel for domestic cases in Singapore. Registered foreign lawyers may generally represent parties in the SICC so long as the case has no substantial connection with Singapore. Within the span of a single year since its establishment, we have already begun to see glimpses of the SICC's truly international character. As at the end of February, more than 60 foreign lawyers, many of them Queen's Counsel or Senior Counsel, have sought and obtained registration with the SICC. And in a historic development, the first SICC case was managed by a Singapore judge sitting alongside 2 international judges and receiving submissions from legal teams helmed by eminent Singapore Senior Counsel and with submissions on foreign law made by foreign legal experts who were registered with the SICC. The second SICC case is being presided over by an international judge who has conducted case management conferences both in person as well as over video conference and has heard the trial in Singapore. Tapping on the global talent pool has opened the door for the SICC to emerge as an international court for the resolution of transnational commercial disputes. I believe that improvement and betterment will come about more quickly with the free flow and exchange of ideas and best practices in this talent pool. We must tap on this pool that we have at our disposal, especially since it has never been easier to do so than it is today. It is perhaps appropriate to draw my address to a close by quoting from Professor Pound himself. Professor Pound was a legal scholar and thinker who was well ahead of his time and who passionately argued that law must continue to adapt to the needs of society. In one of his most famous quotes, he said, "The law must be stable, but it must not stand still." Indeed, the major shifts in the global landscape that we're witnessing today ought to remind us that our legal systems cannot stand still. The quest to improve the resolution of disputes and to enhance access to justice must be a continuing one. We in Singapore have recognized these major shifts and the concomitant need for an organized response to them. We're committed to ensuring that we can meet the demands of the exciting and legally diverse region that we serve. To this end, we have sought to develop an array of dispute resolution capabilities designed to meet the varied needs of our stakeholders. We're blessed with a judiciary that enjoys a strong reputation for integrity, efficiency, and trustworthiness. We also have developed very well-regarded institutions such as the Singapore International Arbitration Center and the Singapore Mediation Center. The SIAC has been actively promoting arbitration for the resolution of transnational commercial disputes and providing quality and neutral arbitration services to the international business community for many years. As for the SMC, the Singapore Mediation Center, it has an admirable track record in mediating disputes. And in terms of training mediators, the SMC has been engaged throughout the region from the Middle East to the Pacific. We recently launched the Singapore International Mediation Center, which comprises mainly international mediators with a focus on international commercial disputes. With mediation gaining traction, we also decided that it was timely to establish the Singapore International Mediation Institute, otherwise known as SIMI, in 2014. SIMI was set up to ensure professionalism and to raise standards in mediation. It acts as the professional body for mediation in Singapore and will certify the competence of mediators, apply and enforce world-class standards of mediation, and uphold professional codes of conduct and ethics. SIMI mediators are also required to meet renewal requirements, which include the responsibility of mentoring young mediation professionals. We've also established institutions to promote the exchange of ideas and dialogue among stakeholders. In 2015, we launched the Singapore Judicial College, which boasts not only training resources for local and foreign judges, but also an empirical judicial research wing that already has a number of exciting projects in the pipeline. I've also spoken of ably. Today, I'm proud to announce the launch of the Singapore International Dispute Resolution Academy, or SIDRA. SIDRA is the first regional hub dedicated to training and educational excellence in negotiation and dispute resolution. SIDRA has been established to complement our suite of dispute resolution services, capitalize on our track record in dispute resolution training, and draw on the competencies and talents of our world-class dispute resolution institutions to offer outstanding training and educational opportunities for the wider region. SIDRA will collaborate with both local partners and renowned international institutions to offer these opportunities. Significantly, SIDRA will also offer an international platform for exchanging and developing ideas on the theory, practice, and policy affecting dispute resolution. And in so doing, it will bring a strong presence of contemporary Asian voices into the global conversations on dispute resolution. Lastly, we have also embraced the opportunity to host conferences dedicated to discussing the need to reinvent and reimagine the way we approach dispute resolution. The future of dispute resolution and our commitment to enhance access to justice will inevitably be greatly facilitated by such ongoing conversations among the various stakeholders. This is why we are greatly honored to host the first of the Global Pound Conference series, which, as has been mentioned, will conclude in London next year. The series provides an outstanding platform for the exchange of ideas. It will convene all stakeholders in dispute resolution and, in the words of its own mission statement, provoke debate on existing tools and techniques, stimulate new ideas, and generate actionable data on what corporate and individual dispute resolution users actually need and want, both locally and globally. It is my great pleasure to welcome you all, and I wish this conference and indeed the entire Global Pound Conference series great success. Thank you very much.